Question B, in the cases of Brown v. Board of Education, 1954, and Dobbs v. Jackson, Women's Health Organization, 2022, was the Supreme Court justified in overturning long-standing precedents given the doctrine of stare decisis? Evaluate the court's reasoning in both cases and how it aligns with our or deviates from this principle. Under what circumstances, if any, should the process of overruling long-standing precedents be addressed through constitutional amendments, new legislation, or a combination of both? And recently, many proposals have been made to modify the Supreme Court's structure or procedures, such as imposing term limits or increasing its size. Do you agree with these proposals, or do you favor leaving the court in its current form? Explain, and I forgot to have them to introduce themselves.
Well, they can leave.
Okay, good, thank you.
The doctrine of stare decisis embodies humility, the recognition that those who came before us may have seen truths we now overlook. Justice Antonin Scalia. The principle of stare decisis, a doctrine that requires standing by established precedent, is crucial for maintaining consistency and ensuring the rule of law is applied evenly throughout the courts. When overturning precedent is up for consideration, we propose applying a two-pronged test. 1. Foundational flaws in the original decision. And 2. Changed circumstances. For foundational flaws in the original decision, the court would ask whether or not the case involved a clear misinterpretation of the Constitution or relied on outdated authorities. Changed circumstances requires evidence of changes in society, whether through scientific discovery or current systemic injustice. With this proposal, stare decisis doctrine's purpose to maintain consistency would be respected simultaneously with the progressive demands of a changing society.
In our two-pronged test, Brown v. Board of Education was clearly justified in departing from the principle of stare decisis. In a unanimous decision, the court recognized foundational flaws in Plessy and acknowledged the evolving understanding of equality. Applying the first step, the Fuller Court relied on the flawed doctrine of separate but equal, which strayed from the intent of the 14th Amendment. Brown also met the second prong due to concrete scientific evidence of Brown's doll studies that prove the psychological harm caused by segregation. However, in Dobbs v. Jackson, the 6-3 decision failed to meet both standards. Although Justice Alito argued the Constitution makes no reference to abortion, this textualist approach ignores the long-standing development of due process under the 14th Amendment. Dobbs was also plagued with inconclusive medical studies on when life begins, showing the unsettled scientific and moral debate that reflected only the political shift of the court rather than a clear societal change.
When the Supreme Court's decisions invalidate the interests of the public, constitutional amendments and new legislation become necessary. As Alexander Hamilton wrote in Federalist 78, the judiciary has no influence over either the sword or the purse. The court reserves no enforcement power. Therefore, Congress may take action when the court fails to overturn unpopular precedent. It can first use amendments to directly overrule errors within precedent, such as in Dred Scott v. Sanford with the 14th Amendment. They can also address the effects of a decision using legislation. For example, Congress may circumvent Dobbs v. Jackson with the legal protection of reproductive rights. The Supreme Court may not deem abortion a constitutional right, but Congress can still protect it, whether through amendments to directly overturn rulings or legislation to mitigate their effects. Both approaches serve as a democratic safeguard against the overreach of the judicial branch.
Recently, there is a renewed interest in reforming the Supreme Court due to their highly controversial decisions that have lost our citizens' trust in the court system. Senator Joe Manchin and Senator Peter Welch introduced Joint Resolution 120 to impose 18-year term limits on the justices, allowing for more viewpoints and ideologies in the Supreme Court over time. After these 18 years, they'll be allowed to return to judging in the lower courts. However, this does not fix the issues of ideological divisions in the court. Adding 4 new justices to the bench, allowing for 13 judges instead of our 9, will combat this issue. Article 3 of the Constitution gives Congress the power to change the Supreme Court, which should be used to add more justices so that ideologies will not lean too much one way or the other. This lack of consistency leads to public distrust in the Supreme Court. Therefore, we should add and reform the justices' power if we want to keep citizens' trust in our court system. Thank you.
So you talked about how sometimes the rules can be changed or laws changed based on public or what's going on in what ways do public opinion and societal values affect the Supreme Court's decision to overturn long-standing procedures?
We see that with our current Supreme Court, it is more conservative, and the public understands this. And I do believe that also the public is starting to become more conservative. We see that with the Dobbs v. Jackson ruling and how the abortion was left up to the states, which can regulate it much more. And most recently, just 3 days ago, the Idaho State House passed a resolution that would go to the Supreme Court and basically say that Obergefell v. Hodges, which gave the right to same-sex marriage, should be overturned. And this really just shows how just the public's opinion on just one major landmark case that really established a liberty of ours can really change the decision of the Supreme Court.
Well, in the topic of the society's opinion, the Supreme Court is supposed to be independent of that. The Supreme Court doesn't reflect the will of the people, but protects our liberties when the society has failed us. We can see in Brown v. Board of Education, when they overturned Plessy v. Ferguson, we saw that the society still agreed with segregation, but the court realized that that was unconstitutional, that people were segregated based off of race, and that these young girls could not go to school just because they were black.
So in Brown v. Board of Education, the decision was based on the 14th Amendment. And the justices felt that there was a fundamental right to education. But that's not what they saw in Dobbs. But they set forth criteria in Dobbs, which is akin to what you stated in your affirmative presentation about looking at different factors. And one of them was workability. And specifically, deciding whether a precedent should be overruled depends in part on whether the rule it imposes is workable. That is, whether it can be understood and applied in a consistent and predictable manner. Do you think that Dobbs did that? Do you think that it lent itself to being predictable and providing a consistent position?
I don't think that Dobbs was very workable at all. I mean, in a Roe v. Wade, they set this trimester test to the state saying that you must put the mother's health before the child up until the 3rd trimester. But in Dobbs v. Jackson, they simply handed it back to the states because they declared that in the Constitution there was no right to abortion, despite previous presidents being set that had this right set already.
Though I believe that Roe v. Wade was legislating from the bench, I believe that if the Supreme Court gives more specificity into a court decision instead of declaring if a law is constitutional or not, I believe it incites judicial activism. And as the founders intended, judicial independence should be preached. And for Dobbs v. Jackson, I believe that it was constitutional. It was constitutional for them. It was right for the Supreme Court to give it back to the states, as there was no deliberate legislation from the Supreme Court, though I do believe that it was wrong in where they demanded that all states return to their states' rights of having the ability to judge abortion. When contrast to Brown v. Board, there was the term of with deliberate speed, meaning that they gave time for staff to desegregate, which was not given to the states today.
All right, so I thought it was interesting, your two-part test you talked about at the beginning, and if I can read my notes here, the one thing was, is it foundationally flawed? And then you said, was it based on outdated authorities? It's one of the ways you find foundationally flawed, I think. So if you're is that type of analysis compatible with, the analysis that justices have been using, certain of them, of, originalism and original intent? How can that work if you're still going to have original intent?
Well, our two-prong test, the first prong about foundational flaws, is basically kind of combining the different interpretations of the judicial branch. We're not saying that it should confine with originalism or textualism or pragmatism. We're saying that we should just look at the Constitution and interpret it in the ways that we would like in order to see that we are still following it. That is the role of the judicial branch, to interpret the Constitution. It isn't to put out any random legislation from the bench and just say that this is the test, this is the undue burden test for Plessy, or not Plessy, but Planned Parenthood v. Casey, or the 3-trimester test from Roe v. Wade. It is, for example, we see that in Mapp v. Ohio, they overturned the precedent of Wolf v. Colorado, which was basically saying that illegal search and seizures are allowed to be used in the court. And in Mapp v. Ohio, they looked at the 4th Amendment and they said illegal search and seizures are not allowed to be used in the court. This is what the amendment's purpose is, and they said that this ruling was wrong, and that could be concluded from any justice with any interpretation.
I believe you spoke about originalism within the Supreme Court, but there's also other perspectives that Supreme Court justices may look into. For example, modernism. Modernism is when Supreme Court justices interpret the Constitution in today's society and today's values. For example, with the case of Lawrence v. Texas, it overruled the case of Bowers v. Harwick, and this was when the Supreme Court took in the opinions and the values of modern society and allowed for the progressive movement of gay rights into our society, and that is when the Supreme Court is right in interpreting the Constitution in a more progressive way, modernist.
And to answer your question, it's not just outdated authorities. We're looking if it is actually an outdated doctrine. So let's look at the case of Loper Bright Enterprises v. Raimondo. When they overturned the Chevron doctrine, but we saw that they relied on the doctrine, on papers of the APA, specifically Section 5 U.S.C. 706, and this just stated that the courts should refer to the scientists, the people in the federal agencies, because they are more well known on when the statutes are unclear. However, it was not outdated. It was a clear the APA doctrine. It was not unclear. So
Not subject to interpretation usually.
exactly.
Okay.
Yes.
With one of the things that was mentioned earlier was about the expansion of the court. Talked about term limits at that with respect to 18 years, but you also mentioned about expanding the court. How would that help? How would having 13 justices versus 9 change anything?
I believe that having 13 justices on our Supreme Court could significantly help with the leading ideologies. For example, if we had 5 conservative justices, 5 progressive justices, and then 3 impartial, which would lean one way or the other, it would put the vote on these 3 instead of one person, which has been done in the past, for example, with Justice Kennedy.
Justice Kennedy is an example of why we should not expand the court because of those ideologies, specifically political ideologies. I mean, we saw in former President Franklin Roosevelt's court packing plan of 1937, he wanted to expand the court just because they weren't following his New Deal policies. And this is a perfect example on why expanding the court is called a third rail in politics, because we should not expand the court, because every single time that it has been expanded, that it was in the political interest of the president.
I agree with my colleague. I mean, we see that in Article 3, Section 2 of the Constitution, judicial independence is very important. And if we do expand the court, we would be politicizing the court and we would be taking away from judicial independence. The ideologies of the president, the ideologies of the Senate, which confirm the justices in the court, would determine the people that would represent our country and represent our ideologies, and we see that those people are currently very polarized and very radical in their agenda, so I believe that we shouldn't expand the court, unlike my colleague Lorelai.
On the contrary, I believe that the Supreme Court isn't matching the values of our society right now. As we can see, like the Supreme Court has a lack of adhering to the code of ethics a code of ethics that is not enforced. As we can see, there are plenty of cases where the Supreme Court justices should be recusing. For example, with Justice Clarence Thomas, his wife was involved with the January 6th insurrection where she placed her flag upside down, yet he still decided on the case of Trump v. US. And in this case, we advocate for a code of ethics for the Supreme Court to follow, so we can more easily trust them as a society.
Thank you.
Very good.
First off, I'd like to thank you all for an engaging conversation where it actually felt like we were hearing opinions, disagreements, agreement with, so it was really refreshing to know that we can still agree to disagree, and for me, not being a lawyer, that I could actually understand where you were going with what we should be doing, and I'm with you. It kind of seems like sometimes that the Supreme Court is just there. Okay.
Well, I thought you did a wonderful job. Your opening and the presentation of the two-prong test was brilliant. I mean, it really was, because of the fact that that is what the court talks about in Dobbs. I mean, they set forth those factors, and they talked about, like I said, the workability, which is, will this actually work in society? But they didn't really want to talk about where society was at the time. They just focused specifically, as you know, on whether or not Casey and Roe v. Wade were wrong. And then they pushed it back to the states and said, there you go. So I thought that you did a really good job of addressing that, because you're not criticizing Dobbs, but you're saying there's a better way to do it that also takes into consideration the Constitution and what was intended and the societal norms. And I think that when you look at the cases together, that's the intent, but that's not what you obviously see in Dobbs. I think that your passion and everything, and I like that, because when you feel strongly about something, you could tell you were being passionate about it, and I think that that's really important to the judges, because it not only demonstrates that you understand things, but that you really thought about it and it's important to you. Monica, I thought that there was following the magistrate's question, there was a little bit of a pause, but you jumped right back in. I mean, I think that that's what makes a competitive team like yours so strong, because of the fact that there's going to be random questions, or there's going to be things and you're thinking ahead and stuff, but when you're able to respond that way, and then all of you jumped in so well, it really demonstrates the strength of your team, and you are a very good competitive team and will represent the state of Nevada very, very well.
All right, well, I certainly agree with that on the enthusiasm. I was also really impressed because you went sort of far afield in different areas that related. For instance, the Chevron case, which to bring up, and then of course you just blandly talk about the APA. I don't know how many people know that's the Administrative Procedure Act, but it's clearly someone has thought about that and looked into it, and no, that was great. And all of you really made good points and made good references to things that affect the court. I guess I have to comment also on the Code of Ethics. I was a U.S. magistrate judge. All the federal judges, other than the Supreme Court justices, are subject to the Judicial Code of Ethics, and we're very familiar with it. I think the thinking has always been historically that the Supreme Court justices, can be relied on to comport with the spirit of it, not the letter of it, because who's going to enforce it? See, that's the big deal. The Supreme Court justices have to be independent. You can't have the president, saying they violated their thing. It's a real tough thing to do. I'm confident people like you that care about civic, you'll find the solution to this problem before we go too much further in history. So anyway, thank you very much for participating. I really enjoyed it.
And again, we like to take the opportunity to say thank you to your judge and to your families that have helped you along the way.
So nice to meet you. Thank you.
Oh.